Good evening, ladies and gentlemen. It's my absolute pleasure to welcome you to tonight's CPD on Robodebt and Brereton issues for in-house counsel. My name is Matthew Cobb-Clark. I'm a barrister at level 22 chambers. Sitting to my right is Dr. Amanda Sapienza, who is also a barrister at level 22 chambers. And to my left is Kate French, who is in-house counsel at OFX. I'm absolutely delighted that they are both able to join me tonight. Those online are sitting in various locations all around Australia, but I'm here on Gadigal country, and I acknowledge the Gadigal people of the Eora Nation as the traditional owners of this land, and I pay my respects to their elders past, present, and emerging. Before we get started with two very interesting but topics that seem to be somewhat disparate on the surface, but when you actually drill down into them, there's a lot of interrelationships and commonalities that we're going to draw out tonight. But before we get stuck into the presentations themselves, I'd like to find out a little bit more about you, Kate. So can you tell us a little bit about your professional experience?
Yeah, sure. Thank you, Matt. So I'm a senior legal counsel for the APAC region at OFX. I have over 20 years legal experience across roles in both in-house corporate, private practice and the government sector in various jurisdictions. I've been working in in-house counsel roles with publicly listed companies since around 2013, and I moved into working in the financial services industry in 2019 post the Hayne Royal Commission, and I've worked in both non-legal and legal roles during that time.
So what does OFX do?
OFX grew from the idea that that there had to be a better and fairer way to move money around the world. That was over 25 years ago. We now have over 1 million clients, and our clients carry out transfers to over 170 countries around the world. So although we started as within the FX industry, we're now more than just international transfers, and we've actually grown into a global payment solutions provider. And we have a new platform which we've just launched that helps companies streamline their global financial operations.
Yeah. With all of that activity, no doubt there's a lot of complex legal issues that arise. Can you tell me a little bit more about what the legal team at OFX is like?
Sure. As we started small in Sydney, the legal team has grown as the company has grown. So our head office is based in Sydney. In my role for the APAC region, I have two reporting lines. So I report into the Chief Legal Officer and Company Secretary for OFX Group, being the publicly listed company. And second to that, I also work directly with the APAC commercial team, and that includes the regional president for the APAC region, and I sit as a member of his senior leadership team. We have senior legal counsels now based in the UK and in Canada. They've got expertise within those particular regions where we operate. We also have offices across the UK and Canada as well. Within Sydney, because our head office is based in Sydney, we have a bigger legal team in Sydney with other senior legal counsels plus the Chief Legal Officer with backgrounds across privacy, mergers and acquisition. Me personally started off as a litigation lawyer, so there's a breadth of experience and knowledge within the team.
That's fantastic. I'd like to hand over now to Dr. Amanda Sapienza, who's going to take us through some of the issues that arise, in particular for lawyers, stemming from the Royal Commission into the Robodebt Scheme. But before we do that, and Amanda has very kindly prompted me on the slides, I'll give a very quick overview of tonight's presentation. So we'll look at first at the ethical issues that Robodebt raises. Ethics in the context of military lawyers, which I know is a bit of a deviation from the usual sort of thing that you might hear in a CPD, but trust me, it actually does, in my view, have relevance to in-house counsel and lawyers more generally. And we'll look at some of the ethical issues that arise from these two reports in the context of in-house legal practice. And we'll talk with Kate about some strategies that could possibly be adopted to address the issues. We'd like, as best as possible, to keep tonight's presentation under Chatham House rules, and that includes for the people online. So to be clear, we prefer that you not attribute anything that you hear said in these presentations to any one of us, although you're welcome to discuss amongst yourselves what was said generally by each of the presenters. And to be quite clear, Kate, as I understand, is not formally speaking on behalf of OFX, and I tonight have my barrister's wig on instead of my slouch hat. And although I happen to be a member of the Army Reserve, to be quite clear, I'm not speaking tonight on behalf of Army, the Australian Defence Force, or Defence. And everything in this presentation, including the sections where I discuss the Brereton Report, is based on publicly available information. So with the formalities out of the way, I'm delighted to hand over to Dr. Sapienza to talk to us about Robodebt.
Thank you, Matt. Thank you for coming tonight, and thank you to everybody online. So I'll talk about Robodebt, the Royal Commission findings and the issues that it found with the conduct of in-house government lawyers. I think most people have at least a vague understanding of what Robodebt refers to and some of its problems, but I will give a brief overview to refresh your memories. What was Robodebt? Again, very broad overview. It's centred around Centrelink's online system to automate the identification and recovery of overpayments. It was called the Online Compliance Intervention. Centrelink would data match their own information with records held by the Australian Taxation Office and work out if recipients had been overpaid. This was rolled out in July of 2016. It was an early example in that way of automated administrative decision-making. But the data matching itself wasn't new. That had been happening since 1991 to detect overpayments and to recover debts. But previously, Centrelink officers had followed up discrepancies that had been identified through that data matching. They would review the person's Centrelink records and contact them to give them an opportunity to explain how the discrepancy might have arisen or provide more information. And if there was no satisfactory explanation, the officer would obtain detailed information about the individual's income and employment, whether from the individual themselves or from their employer. And all the information they obtained was then used to work out what the person should have been paid in Social Security. And that was a complex calculation due to the different frequencies of payments, of Social Security payments and income, and the different frequencies of those two receipts of money, and various adjustments that needed to be made for things like leave or other credits. So the correct rate of payment, what they should have been paid, was then compared to the amount that they were paid, and the difference for that debt was negative, was the debt for the fortnight for that person. So that was the way the system was operating. Why the change? Well, in 2014, the Department of Human Services was developing proposals for recovering overpayments caused by underreporting by Social Security recipients of their income. And that department estimated that if they could automatically calculate debt using employer-reported PAYG information that they received from the ATO, the savings over 4 years would likely approach $1 billion. So the solution was the Online Compliance Intervention, now known as Robodebt. The online system automated that process that I've just outlined, in some cases partly, and in some cases fully. So when the system detected a discrepancy with the ATO data, the system automatically generated a letter to the person, and that person by then might have still been current Social Security recipient or might have been a former Social Security recipient. And apparently the system generated 20,000 letters a week compared to the 20,000 letters a year that had been generated before that. The letter advised the person that Centrelink had information from the ATO that differs from information they've provided, so please log on to the system within 21 days to check the information. Once the person logged on, the ATO information would be displayed, and the person had the option to advise whether they agree with the ATO information or whether they didn't agree and wanted to provide additional information. And the system then used the ATO information and any additional information that might have been provided by the person to see whether there was any debt. In some cases, a Centrelink officer may have gotten involved, but in most cases, this apparently happened all automatically. It used expert systems, pre-programmed rules-based processes. So for every input by a person who provided information, there was a pre-programmed output, which was based on business rules that had been plugged into the system. They likely based on legislation or agency policy. So as I'm sure you can imagine, there were a number of tech issues. So there are systems issues, out-of-date information, access, the stuff you'd expect. But tonight I want to focus on the legal issues. And principally, was the decision one that is actually authorised by the statute? Did the coding of these rules actually reflect the law? Did it compute the things that the law required the system to actually compute for a debt decision to be made? So the fundamental issue of legality, is this the kind of decision that the statute authorises? This was a big issue for Robodebt and was what ultimately brought it undone. There were two issues. First, the double counting. The system double counted income when the employer name reported to Centrelink by the employee didn't match the employer name recorded by the ATO, because ATO records use the formal company name of the actual legal entity that owns the business. So, you know, such and such Holdings Proprietary Limited. And employees frequently don't know that legal name of the entity. They know the name of the place where they work, the shop, the cafe, the restaurant, etc. Another example of a legal issue, and this was the big problem, was that in some cases, such as where the person didn't respond within the 21 days, or the person simply confirmed the ATO data without providing more information, maybe because the actual amount on the ATO data was the same as what their own records showed, the system was programmed to assess a debt by averaging the person's annual income over the period of their employment as recorded by the ATO. So the system assumed that the person's income was the same for each fortnight. This led to miscalculation of debts for casual workers or people who were only employed for part of the year. And the system was actually designed to do this. This averaging was seen as the price of automation, and the legality of that averaging was a huge issue. Some provisions of the relevant legislation, the Social Security Administration Act, authorise averaging in limited circumstances, like the age pension, which is a regular amount every week, but it didn't authorise it for most individuals affected by the new system who received unemployment or student benefits and were paid irregularly in their jobs. The lawfulness of this averaging was challenged in the federal court, and a week before the matter went to hearing, the government conceded that the averaging Robodebt was using was unlawful. This was in Deanna Amato's case. Sorry. Okay. I'll talk about this case in a bit detail so you appreciate kind of what was actually happening on the ground. Centrelink raised a debt in 2018 in respect of payments that Ms Amato received as a student in 2012. And Ms Amato only found out about the debt when they garnished her $1,700 tax refund, as the Centrelink notices had, surprise, surprise, been sent to an old address because she wasn't receiving Centrelink benefits anymore, so she didn't need to keep them updated about her address. So a $2,900 debt was raised. This was reduced to $1.48 because later through FOI, she realised she'd actually been underpaid. The Commonwealth refused to pay her interest, and the issue went to the federal court, where, as I said, it settled right before the hearing. Justice Davies took the rare step of adding a 15-paragraph note to the consent orders to explain them, stating that the conclusion that Ms Amato had received Social Security benefits to which she was not entitled was not open on the material before the decision maker, because there was no probative material before the decision maker supporting the averaging assumption that her income was earned evenly across every fortnight. But there was probative material before the decision maker, her actual reported earnings, that showed she had not earned the same amount every fortnight. In those circumstances, the court said the conclusion that a debt had arisen was irrational in the requisite legal sense. The Commonwealth had to pay her costs and the interest that the case was about, which was the grand sum of $92, one might think a judicial note that a key plank of your automated system is invalid was a hefty price to pay for $92, but anyway. Ultimately, the court essentially found that, as AAT members, practitioners, academics had been saying for some time, the Commonwealth has to prove a debt exists. A person doesn't have to prove that a debt did not exist. So, a few system refinements, 5 now public adverse AAT decisions, 76 non-public AAT decisions, 2 Commonwealth Ombudsman reports, 2 Senate committee inquiries later. In May 2020, the Commonwealth agreed to repay $721 million in wrongfully collected debts. On 30 June 2020, the Robodebt scheme ended. And in November 2020, the Commonwealth agreed to add $112 million in compensation and not to pursue a further $398 million in debts that have been wrongly raised. So settlement worth $1.2 billion kind of wipes out that billion they were trying to save by Robodebt in the first place. But again, that all got settled a day before a class action was meant to commence. And of course, on top of that, we got the Royal Commission, where a lot of this was revealed. The Commissioner was Catherine Holmes, ACSC. She was former Chief Justice of the Supreme Court of Queensland. She presented her report in July 2023. It was 1,052 pages of public report. And an additional chapter that she recommended remained sealed, not tabled with the rest. This chapter recommends individuals for civil action and criminal prosecution. Parts of that chapter went to some heads of Commonwealth agencies, Australian Public Service Commissioner, Australian Federal Police, the National Anti-Corruption Commissioner, which you may have read in the media recently, decided in June not to commence a corruption investigation about this, essentially on the basis that it was unlikely to uncover any new evidence, and unlike other bodies looking at it, like the Australian Public Service Commissioner, the NACC can't grant a remedy or impose any sanctions. But notably, for present purposes of our in-house lawyers, the Commissioner also submitted parts of the sealed chapter to the President of the Law Society of the ACT, which is certainly an indication of what she thought of the role of some of the lawyers in all this. Which brings me to the Commissioner's findings. And I'm going to focus on the role of in-house counsel and the findings related to them, because there were mountains of findings made about a lot of things. The legal issues seem so obvious as we speak about them now. So where were the lawyers in all of this? The warnings were there from back in 2014, when the idea for the scheme was first floated in the Department of Human Services. The project required the cooperation of 2 departments, both the Department of Human Services as the department with responsibility for improving social and health service delivery, and the Department of Social Services as the department with responsibility for the administration of social security law. So DHS was policy around social security, DSS was administration of social security, including compliance. There was extremely close working relationship between the two that was spelled out in formal agreements, such as that one that I've referred to on the slide. And from the very start, DHS was keen to get the scheme going to achieve these budget savings, and DSS was warning, on the basis of internal legal advice from their principal legal officer, that the proposal could have significant implications for social security policy and legislation, and was unlawful and would require legislative change. DHS said it only required a policy change. An officer from DHS did seek legal advice, the Commissioner found, from a legal services division in about January of 2015, but the Commissioner found the instructions didn't get at the heart of the problem. They essentially asked for advice on a side issue, didn't ask about the income averaging. In January 2015 also, DSS advised that it did not support this proposal because it wasn't consistent with legal advice, would not be supported by law, and was counter to social security policy. That went all the way up to the Deputy Secretary of DSS. But by that time, we're still in January of 2015, the Minister for Social Services, Scott Morrison, had made it clear publicly that he wanted to achieve budget savings through his portfolio, and he would do it by cracking down on welfare cheats who wrought the system, and he would be known as the welfare cop. It was clear from the evidence the Commissioner found that if the scheme required legislative change, it wasn't going to happen. So the overall messaging to the departments, the Commissioner found, was find a way to make this work. And you can see it in findings made about the conduct of the two departments. She said, and if you want to have a look, this is on page 107, the failure of DSS and DHS to give Mr Morrison frank and full advice before and after the development of the proposal is explained by the pressure to deliver the budget expectations of the government and by Mr Morrison as Minister for Social Services communicating the direction to develop the proposal through a particular executive minute. A pilot of the program was rolled out in May to June of 2015. It was largely unsuccessful. 60% of people didn't respond, but the draft brief to the Secretary failed to give a realistic picture of the results of the pilot. And the Commissioner found that this could have either been because the Secretary was only informed of the results orally, or because the results were not given to her at all because of the fear of delivering bad news that was apparent from various witnesses' evidence. And we see that reflected in the Commissioner's findings specifically about legal consideration of the scheme. By January 2017, internal legal at DHS had also formed the view, like DSS held, that department could not do the income averaging. That would by then already been occurring. A view was taken that Australian Government Solicitor, AGS, should be retained to provide advice, independent advice on the topic. But the Commissioner found that the Secretary of DHS instructed DHS officers to cease the process of seeking that independent advice. This instruction was motivated by concern that the unlawfulness of the scheme might be exposed to the Ombudsman, who was in the course of an investigation, started an investigation at the time. And around that time, January 2017, the Principal Legal Officer of DSS, that was the person who'd initially advised it was unlawful, she provided heavily qualified advice that income averaging as a last resort was lawful. She gave evidence she felt pressured to provide an answer that justified taking action that the general advice in 2014 couldn't have supported. DSS then relied on that heavily qualified advice to tell the Ombudsman the scheme was lawful. They didn't provide the Ombudsman with the 2014 advice. And then, having used various means, the Commissioner found to influence the contents of the Ombudsman report, both departments and the Minister used that report to justify the legitimacy of the scheme. There were also AAT decisions querying the legality of the scheme, which Departmental General Counsel took it upon themselves to disagree with. The new Minister since December 2017, Michael Keenan, he dismissed an article in 2018 by Emeritus Professor Terry Carney, who was a former AAT member, regarding the lawfulness, and it got dismissed an email saying, "A former member of the AAT, what a lofty authority." No legal advice was sought about the issues that Professor Carney raised in the article. There were more AAT decisions, and then in 2018, Acting Group Manager within DSS, instructed, no, we really need to get external legal advice about this, and Clayton Utz was retained. Clayton Utz provided a draft advice in August of 2018. It advised that the legislation in that form did not allow for the averaging of income. That advice went up the departmental chain in a leisurely way. A copy of the draft advice was not provided to the Deputy Secretary till November of 2019, over a year later. An officer became concerned about the fate of the advice and raised her concerns that this could end up in the federal court, and she was told not to worry, it's just one advice and we've got lots of others. The Commissioner found that the Clayton Utz advice was never finalised, despite the firm's invoice being paid. DSS Legal had left it to the other parts of DSS to work out what to do with it, and ultimately that was nothing. The Commissioner found that more than a year after DSS received the Clayton Utz advice in draft, the scheme was continuing, debts were still being raised unlawfully against Social Security recipients. The institution of 2 federal court proceedings in 2019, the Amato proceeding that I mentioned, and then another by Ms Masterton, prompted the provision of external legal advice by AGS and then the Solicitor General, Stephen Donoghue, both as to the unlawfulness of the scheme and which both together sounded its death knell. The Solicitor General's advice constituted an authoritative opinion that the Commonwealth did not have a proper legal basis to raise these debts and recover these debts solely on the basis of averaging. So they're the rather damning findings that the Commissioner made. What did she say could be drawn from them? Within Part 6 of the report, which is entitled Checks and Balances, the Commissioner devoted Chapter 19 of the report to lawyers and legal services. She opens chapter 19 with 3 quotes regarding the important role of government lawyers, including one from our now Chief Justice, the Honourable Stephen Gageler, in a speech to the Attorney General's Department that is on a gave in 2016. Upholding the principles and values of a government lawyer in a time of crisis requires courage and conviction. And the Commissioner noted that the fundamental ethical duty of a lawyer is the avoidance of compromise to their integrity and to their professional independence. We're not mere mouthpieces of our clients. She noted that this obligation takes on extra significance for government lawyers because the government is a client which has powers and obligations that far exceed those of the normal citizen. The Commissioner found it was apparent that the professional independence of in-house counsel of both DHS and DSS was compromised. The in-house lawyers involved in the provision of advice did not uniformly display a professional ethos. DHS lawyers gave evidence of the perception that even when they tried to act independently, they were constrained by the culture of the department, which discouraged that kind of independent behaviour. There was an imperative to stick to talking points, which was prohibitive of lawyers forming any independent view about the accuracy of what they're being told to talk about, whether a matter of law or as a matter of fact. The Commissioner found that the position that income averaging was a lawful practice was long-standing and so entrenched within DHS that lawyers at all levels felt unable to question it in accordance with their professional obligations. Examples included the failure to advise of the weak legal position in January 2017, when in-house DHS lawyers finally came to that view. And the Commissioner pointed out in particular a presentation that was given by Peter Hanks KC at a National Administrative Law Conference in 2017, at which Mr Hanks clearly identified issues with lawfulness, and that had been attended by a number of DHS lawyers. But Chief Counsel of DHS failed to genuinely assess the merits of the arguments that were put at the conference and to recommend that independent legal advice be obtained. And the Commissioner found that this is because Chief Counsel knew that the Secretary of DHS did not want to receive such advice. It was a similar case with that Professor Carney article that I mentioned before. That went to the General Counsel with a summary that disagreed with Carney. It turned out General Counsel actually agreed with Carney rather than the summary, but he didn't tell Chief Counsel that. And the Commissioner agreed with a witness that the strict hierarchical control of DHS presented serious obstacles to the provision of independent legal advice. The Commissioner was critical of Chief Counsel of DHS, saying she downplayed her role to one of manager rather than lawyer. She gave evidence of acting on instructions as the reason why she didn't give DHS senior executives advice as to the weakness of the legal position. But the Commissioner held that the role of Chief Counsel includes the capacity to recommend that the Department obtain legal advice, particularly if a significant issue has been identified. You don't need instructions to make a recommendation of that kind. And the culture of DSS seemed to be similarly deficient. They worked in silos, they didn't consider broader risks rather than just focusing on their own individual bits. Lawyers were only for statutory interpretation, nothing more. Some lawyers were more favoured by the leadership than others. And the Commissioner found that that culture had an effect on the ability of in-house lawyers to maintain their professional independence. The Commissioner notes also that Chief Counsel are now part of the senior executive in each department, and she thought that was problematic because it might not guarantee that there's sufficient separation between the head of the agency and Chief Counsel to ensure that there's no expectation of loyalty from the Chief Counsel to the agency head. And the Commissioner recommended that selection panels for Chief Counsel now include the Australian Government Solicitor. The Commissioner identified many systemic issues with how and when departments sought, obtained, recorded legal advice. She said it was truly striking that despite many DHS and DSS lawyers involved, so little attention was paid to the provisions of the legislation that actually govern entitlement and payment of benefits. The advice by in-house lawyers, she said, seldom referred to legislative and judicial authority and generally failed to undertake the critical analysis that would be expected of a qualified lawyer. So that's a pretty damning indictment of a lawyer. She made recommendations for further training, recommendation that DSS should develop legal practice standards to make sure everyone knows their core duties and their responsibilities. Another alarming feature was the practice of leaving advices in draft form rather than finalising them. The Clayton Utz advice I discussed was one example. Apparently this is quite common. And the Commissioner recognised there may well be circumstances where it's reasonable to obtain advice in draft and then allow further clarification, clarify facts or issues, clarify instructions. However, she recommended to both agencies that unless there's a very good reason, the advice should always be finalised. And if it's not going to be finalised, that very good reason needs to be documented somewhere. After hearing evidence of the Royal Commission, DSS issued a direction about when to seek legal advice, how staff must act on it, and the Commissioner recommended that DHS do a similar thing. In addition to failure to maintain their independence, and in addition to poor practice in respect of legal advice, the Commissioner found there have been many failures to comply with legal services directions, which is a set of binding rules issued by the Attorney-General under the Judiciary Act for performing legal work. And you can see the basis for those in Part 6 and 7 of Chapter 19. We don't have time for discussion of that now, but one aspect that I did want to raise, it's of broader significance, was that of legal professional privilege. The department was obliged by one of these directions to share advices with another department if they took the view that the opinion that they'd gotten was significant to another department. So that was obviously the case in matters between DHS and DSS. The Commissioner heard it's common practice for them not to share the legal advice because they wanted to maintain confidentiality and legal professional privilege. The Commissioner found that that reflected a misconception among Commonwealth officers. The legal advice provided within the Commonwealth in accordance with directions does not involve waiver. Disclosure of that advice does not involve a waiver of privilege. She referred to the case that's on the screen. And in that case, Justice Edmonds had observed disclosure between the Attorney-General's Department and AGS in that case didn't constitute a disclosure for the purposes of waiver because we're talking about one body politic. We're talking about one entity. There's a single interest of the Commonwealth. So that was the shameful period in public administration that was Robodebt. The Commissioner obviously made a ton of recommendations. The government says she made 56. They accepted in principle all 56 of the recommendations that they said the Commissioner made: more training, more funding, better recruitment practices. And it was also noted that the new Administrative Review Tribunal, which is going to replace the Administrative Appeals Tribunal, is going to take on some of the load of preventing maladministration like that from happening again. So that is, as I said, Robodebt. Obviously, it's very focused on the conduct of in-house lawyers within government, but I think there are tie-ins with the challenges that would face private sector in-house lawyers as well. I know you probably have a few questions for Kate as well on that, Matt, yeah, so I might hand back to you.
Excellent. Amanda, thank you so much for that. That was a really fascinating look at a topic that raises a lot of critical issues around ethics for lawyers. Kate, we heard Amanda talk about the fact that lawyers are not mere mouthpieces for their clients. And I think that principle applies with equal force to lawyers that work as in-house counsel. They're not the mere mouthpieces for the interests of the companies that they happen to be working for. And we also heard Amanda speak a lot about the need to maintain that degree of professional independence. Obviously, one of the things that governs that, I think, is about the structure and the titles that go with your organizations. I know from reading the Robodebt report that one of the other issues that the Commissioner raised was potential confusion when senior in-house lawyers started to be reduced in terms of status from senior in-house lawyers down to legal managers or managers. Do you think that clarity around responsibilities as in-house counsel is important from an ethical perspective?
Yeah, absolutely, Matt. I would say that you look at when you start in the role and the job description that you're provided for your role when you go in for your job interview. And I would say that that might not necessarily reflect what you do down the line on a day-to-day basis. And that is probably because your role evolves over time. You get more and more responsibilities added on top of once you've sort of got through that first 6-month period. So you need to be aware of the obligations that surround those additional responsibilities that you've put on your plate. For me, for example, I've now got a company secretary role that I didn't have when I first started, so that's a whole different area of governance, agreeing to take on that role. But also the other thing I wanted to say was we do really wear two hats. We wear our legal advisor hat, and I'm very mindful of that, and I'm very mindful of the fact when I'm acting in that advice capacity, to the extent that when I feel like I'm exercising the advice role, I will clearly mark my advice privilege and my emails before I send it round, so you can see at the top that I'm considering that I'm providing legal advice and I'm properly expressing that by marking it privilege. But we also do wear our commercial hat. We're involved in, commercial decisions and structuring deals and what have you in agreements. So it's having the clarity around what the obligations are that are linked to, the position that you're undertaking.
Yeah. So you talked about your role kind of evolving over time, presumably in line with how the needs of the business evolve as well. So have there ever been sort of points in time where you've thought to yourself, gee, I'm not entirely sure about the clarity of the role or the scope of the role that I have? And if you have, how do you sort of address that issue?
I would probably say personally, no, not really. But I'm not sure if that's probably linked into where I'm at in my career. When you're a senior lawyer that's been doing it for a long time, particularly even sitting in an in-house role for decades, I think you feel very comfortable with, what your role involves and the expectations that are placed upon you. I would question if junior lawyers would feel differently, particularly juniors coming into an in-house role from private practice. It's a very different environment, and I would really question if they really understand in those early stages of, what is quite a big career transition across, if they would feel the same as a senior lawyer that's, been around the tracks.
One of the other things that Amanda mentioned in her presentation was the fact that these DHS and DSS lawyers were going to these conferences and going to these CPDs and hearing presentations that quite squarely raised issues of concern around robo-debt and were pretty explicit warnings about the fact that the program might not be all that legal. What, if anything, do you think is in-house counsel's responsibility for actually, when they go to those kinds of presentations, to actually disseminate that knowledge to the organization?
I would say absolutely. There is an expectation on us to keep abreast of regulatory changes, potential new legislation being considered within the industry, and to share this knowledge with the key stakeholders, whether it be employment law changes and communicating that to the people and culture team, or general sort of payments in my industry, payments legislation being considered and the appropriate operations team or what have you. We also are sometimes involved in making submissions in relation to potential new regulatory changes being considered. So we like to take the opportunity to put forward our position if it's something that we feel like we want to have a say.
Excellent. I want to change tack a little bit and see if we can talk a little bit about the Brereton inquiry into special forces in Afghanistan. I'll start with a little bit of kind of a brief factual overview. The inquiry looked at something called Operation Slipper, which was Australia's contribution to the International Security Assistance Force in Afghanistan. It concerned the actions of Australian Defence Force members who were deployed to Afghanistan as part of that operation, which lasted from about 2001 until about 2014. What is interesting is that although everyone most likely recalls that we sent over various members of the ADF, including regiments of special forces, One of the interesting things that people outside of the Army might not be so aware of is that traveling and deployed with them were a number of legal officers, or as I refer to them in the slides because I'm an Army reservist and we love our acronyms, legalos. They were embedded within the Special Operations Task Group, and they were expected to be able to provide legal advice about a number of issues. For example, targeting in the context of whether something was an appropriate target under international law of war, the law of armed conflict, or whether something was not appropriate, or other issues such as about how detainees were to be managed if they were taken by the ADF. So Operation Slipper happens, and then in about 2014, as the operation was coming to a close, rumors start to emerge of Special Operations Task Group members committing what in effect were war crimes. Special Forces Command engaged a sociologist to conduct interviews in order to investigate the culture within Special Forces. And during those interviews, soldiers described scenarios which the sociologist described as vague, nameless scenarios and off-the-record conversations of things like body count competitions and killing of so-called squirters, who are, squirter was a kind of a informal name given to an Afghan person who was seen running away from an engagement and was then targeted and potentially killed by Australian forces, and other incidents which essentially amounted to the potential covering up of war crimes. So subsequently, the commander of Special Operations Command wrote to the Chief of Army and advised that he had heard a number of anecdotes that were, in his words, deeply disturbing and which implied criminal behavior within Special Operations Command. And in 2016, the Chief of Army wrote to the Inspector General of the ADF and requested a scoping inquiry into these matters, and that later became the Brereton Inquiry. So on the screen there is the task that was to be carried out by Major General Paul Brereton, who was at the time a Supreme Court judge, to look into whether there was substance to unspecified rumors of criminal, unlawful, or inappropriate conduct, including possible breaches of the law of armed conflict by members of the Special Operations Task Group in Afghanistan between 2005 and about 2016. On the screen and on the slide there is some of the conclusions reached by Major General Brereton in his report. There was credible information about 39 allegations of unlawful killings by or involving ADF members. And it's important to recognize at this point that Major General Brereton was not instructed to, and nor did he, come to a definitive conclusion about whether the various allegations in fact occurred. His conclusions are expressed as there being either credible information or the allegations not being substantiated. And of course, it's important to understand that Major General Brereton wasn't conducting any sort of criminal trial. Some of the conclusions reached by Major General Brereton are of particular relevance to legalos, so uniformed legal officers within the Australian Defence Force. And in particular, there were conclusions that legalos were involved in the making of essentially false operational reports. Essentially, when there was contact with a potential enemy, there were what are called after-action reports. Those were drawn up by members of the Special Operations Task Group, and they frequently were sent to legal officers embedded with those units for what was meant to be a legal review, but wound up ultimately being a form of whitewashing in order to get these reports into a form which reduced the likelihood that someone further up the chain of command was going to look into this or investigate what actually happened. And that led to what could generally be described as a failure of oversight mechanisms. So the operational reporting that was coming through from Afghanistan was being manipulated in order to minimize the likelihood of scrutiny. One of the ways in which that was being done was essentially the same form of words being put again and again into these after-action reports. When those forms of words were used to essentially mirror the rules of engagement that were applied at the time. And the idea was that if you put this form of words into this after-action report, then everyone would see and go, oh, well, that looks like it's entirely in compliance with the rules of engagement, nothing to see here, we don't need to do any sort of further inquiries. And over time, the legal officers within these units started to learn what form of words needed to be used in order for these reports to not be the subject of any further inquiry by higher headquarters, regardless of whether that form of words actually reflected the facts on the ground. There was also, coupled with that, a presumption against believing reports that were being made by Afghans of incidents that could have constituted breaches of the law of armed conflicts. And likewise, there were NGOs operating in Afghanistan who were also raising similar concerns. And those were essentially being waved away by Special Operations Task Group on the basis that, oh, well, it's just Afghans and they're interested in compensation, or they just hate us generally. It's all just motivated by animus. The NGOs are just a bunch of do-gooders, and you don't need to pay attention to them either. And so we start from a presumption where that information, which in hindsight turned out to be potentially quite credible, is not being treated with the amount of respect that it deserved. The reason that we speak about this in the context of lawyers, and the reason why Brereton is actually quite a good study of ethics for lawyers, is the involvement of the legal officers themselves in embellishing operational reporting to falsely suggest that rules of engagement were in fact being complied with, when in reality they might well not have been. And Major General Brereton looked at that manipulated reporting, and he says it's likely to be a manifestation of a wider propensity to be inclined to report what superior commanders are believed to want to hear. So that's a phenomenon that I don't think is unique to the military. And I don't think it's unique necessarily, as Amanda was talking about, to government departments. It's this idea that, well, my job is only to report the good news to my higher headquarters, or or to my supervisor, or to the person up my reporting line. I need to tell them only what they want to hear, rather than the bad news that actually might reflect the reality on the ground. And that's obviously a really dangerous thing to happen within an organization's culture. But I think it's something that's one of the links, I think, between the activities of DHS and DSS in the context of Robodebt and the activities of Australian Defence Force legal officers in Afghanistan during Operation Sliver. Another issue that Major General Brereton talks about is this idea of understanding who the client is. Of critical importance to legal officers within Army or within the ADF more generally is this principle. A legal officer's client is the Commonwealth. It is not the unit that they are attached to. It is not their commanding officer. It is not, people within higher headquarters. It is the Commonwealth. And the challenge that generates is that frequently there are conflicts of interest that might well develop between a person, between a unit who's engaged in a particular activity and whose interests might well be in no one looking any further into what happened, and the interests of the Commonwealth, which might well be, it might well be in the Commonwealth's interest to have a full understanding of what was going on the ground. And having the correct understanding of the identity of the client is essential to resolving those conflicts of interest. And in practical terms, legal officers were not closely turning their minds to this issue during their deployments, particularly with regard to potential conflicts between the Commonwealth's interests and the interests of the Special Operations Task Group. And that was particularly challenging in the context of civilian complaints about the use of force and the investigation of possible breaches of the law of armed conflict. In short, it was potentially in the interests of the operators on the ground for these problems to just go away, for no one to look into them any further, and for the operators to be left alone to do what they wanted to do in order to carry out their mission. While at the same time, as I was saying before, that's not quite the position for the Commonwealth more generally. It was in the Commonwealth's interests for them to have a complete picture about what was going on. The difficulty in terms of ethics was that, again, we come back to the involvement of legal officers in this part of the process, where legal officers attached to the Special Operations Task Group were found by Major General Brereton to have been involved in drafting or endorsing reports dismissing meritorious civilian complaints as absurd. The report is very extensive. Major General Brereton's report is publicly available, albeit in an extremely heavily redacted form. And I'll make the same point again at this point that I made at the top of tonight's presentations, which is what I'm working off of is the publicly available version of the Brereton report. The unredacted version is known to a very, very small number of people, and I'm certainly not one of them. But even the unredacted report is well worth reading for people who are interested not just in military operations, but in the ethics of lawyers. Because one of the aspects of that report is what I'll describe as kind of a sub-report prepared by Professor David Wetham, who is a professor of ethics and the military profession at King's College London, who was asked by Major General Brereton to prepare a report addressing the issues that are on that slide. In essence, why did ADF personnel do these things? Why were their actions not reported by anyone? And if senior commanders did not know about those incidents, could they have or should they have? And what Professor Wetham finds is that although the idea of bad apples was certainly a contributing factor, this idea that there were rogue operators out there who just wanted to go and complete the mission, if that meant killing Afghanis in an unlawful way, then that's what they were going to do. But that's not a complete explanation for what happened. A significant point is that there was no suggestion anywhere that anyone that was involved in these matters, no one was claiming that they thought that what they were doing was legit. No one was claiming that they thought what they were doing was legal. Everyone understood that what they were doing was wrong, and yet it still happened, which is a very significant thing to get one's head around. But the final point that is on the slide, Professor Wetham finds that any organization's ethical culture is degraded when even good people feel the need to systematically falsify, fudge, and exaggerate in order to make the system work properly. And legal officers were not immune to that phenomenon. And one example of that is this idea that there was a concern among people involved within special operations about this idea of catch and release of Afghanis. So there would be these incidents where Australian soldiers would go into, for example, a village in order to try and root out Taliban fighters and identify people who were lawful combats. At the same time, they would identify Afghanis who were not necessarily involved in combat, but were still detained by them. The Australian forces would detain them, they would interrogate them, but then they would ultimately decide that they would have to release them. And these same individuals who were released were coming up in these engagements again and again and again and again. And the concern was essentially that although they couldn't pin it on them, they were involved in the conflict. They were either in support of the Taliban or were active members of the Taliban themselves. And it got to the point that rather than engage in this concern where if we just detain them, then they're ultimately going to have to be released, they start to sort of go, well, perhaps we should just shoot them. And so it becomes a problem where they start to become frustrated with how the system operates in their view, and they start to work outside of the system and engage in extra legal measures in order to achieve the outcome that they wanted. Legal officers were not immune to the ethical pressures, and Professor Wetham writes in his reports about how some lawyers from higher headquarters were trying to assert some more control over what they increasingly believed were sanctioned massacres. They tried to tighten up the rules of engagement, but the problem was that lawyers embedded with special forces just got more creative about how to draw up the after-action reports in order to minimize investigation by people further up the chain. So you change the rules of engagement, and all they do is they just change the reports to fit the rules of engagement, regardless of whether that actually was what was happening on the ground. One of the interesting quotes from Professor Wetham's report is this, quote, "As the lawyers started to become more troublesome, the Special Forces unit started to rely more on their own lawyers, with the promise of being inside their elite tent, doing cool stuff, in return for legally polishing their version of events and the truth in a way that created enough doubt so as to exonerate them. So this idea that you can tell these lawyers who are meant to be representing the interests of the Commonwealth, not the interests of the Special Operations Task Group, oh, well, look, don't worry about that. You're one of us. You're with us. You're with the special operators. You're with the cool people within Army. Just, you're on our side. You're on our team. We just need you to do these things to sort of further our interests. And it's a really interesting phenomenon where you have this large organization, but then you have this so-called group of cool people that are trying to exert their own ethical influences over the people that are meant to be protecting the interests of the Commonwealth. So Major General Brereton makes a variety of recommendations, including recommendations that are quite relevant to lawyers. And I've got two of them up on the slide there. One is an alternative safe reporting line that is separate from the chain of command to report or discuss concerns about unlawful behavior. The other point that he makes is that despite a lot of people involved in this inquiry having acted quite shamefully, Major General Brereton does also point out the fact that there were a lot of people that actually did do the right thing. They did expose the misconduct, and they did act with propriety and probity. And Major General makes a really strong point that it's important for the Army that their careers should be seen to prosper. They need to be rewarded for having done the right thing. And I think that goes towards changing culture. Another recommendation that he makes is about this idea of, well, as Kate was talking about, sometimes the role evolves when one is a lawyer within a large organization. The same is true for legal officers who are deployed. Their roles were frequently changing, and the problem was that at the time of Operation Slipper, there wasn't really a clear duty statement that identified what the responsibilities are and are not. And so one of the recommendations, which I think is important for organizations outside of Army, that Major General Brereton makes, is that there needs to be a clear duty statement that identifies who the client is and who their professional duties are owed to, which is the Commonwealth as distinct from the deployed force or its members or the commanding officer. So let's tie these two seemingly disparate things, Robodebt on the one hand and Brereton on the other, together. I want to say at this point that I'm not looking to make factual comparisons between the responsibilities of DHS or DSS staff and the responsibilities of legal officers who are deployed in the Australian Army. And I'm certainly not suggesting that one group is inherently under more pressure than the other. But there is a point of interest for me in these two aspects of these presentations. And that is that at a high level, there's similar pressures and environmental factors that are contributing to the adverse outcomes identified in the Robodebt report on the one hand and the Brereton report on the other. And if that's so, I think it's useful to identify the commonalities, because I think that might indicate that findings around organizational culture in both the Robodebt and Brereton reports might be applicable to the idea of organizational culture as it affects in-house counsel. So on the screen there is a table which sets out what I think some of the commonalities are at a high level about Robodebt and Brereton. And they range from things like, when Robodebt starts to talk about $1.2 billion of savings as not just being the nice consequence of this policy, but rather the end goal in and of itself, you start to see how the inappropriate metrics shape inappropriate actions. And likewise with Brereton, when there starts to become an increased focus on how many enemy were killed in action as being a signifier of how successful a particular operation was. Leadership's actions shape culture. I think that's clear from both reports, whether it's Scott Morrison, Prime Minister, as the welfare cop, or a Special Operations Task Group embracing the warrior culture and taking an aggressive approach towards not just the enemy, but anyone they encounter in their patrols. That you can see how the actions of leadership start to change and potentially degrade the culture. Both Robodebt and Brereton talk about organizational cultures where frank and fearless advice was being discouraged and where bad news was very difficult to deliver and was not willingly received. Also, both Robodebt and Brereton talk about those moments when there was external oversight or external investigation into the activities of DHS or DSS on the one hand from the Ombudsman, or from higher headquarters investigating in the context of Brereton. And yet, despite these investigations, there's still a level of dependence upon people giving them truthful and accurate information. And when that's not happening, you're not able to identify the problems. Likewise, I think there's also a possibility that complaints from groups that were being perceived by these organizations as, quote, the enemy, were being dismissed, despite the fact that if they had been taken more seriously and investigated, the wrongful conduct might have been identified earlier. And then finally, we go back to this idea that Amanda was talking about professional independence. And in the context of Robodebt, the professional independence of DHS and DSS in-house lawyers was compromised. And likewise, the professional independence of Special Operations Task Group deployed legal officers was also compromised. And so, it's important as one facet of that to understand who your client is when you're engaged in either an in-house role or within one of these large organizations. So that's what I had to share about the Brereton Report. I'm hopeful that people in the audience have had a chance to sort of see how this has some of the commonalities with the Robodebt that Amanda was talking about.
Thanks, Matt. There's those similarities that you've drawn out in those last two slides. Of course, it now gets me thinking about how that translates into a private in-house counsel role, like Kate has. This idea, Kate, that comes through from Robodebt Royal Commission and Brereton in terms of telling people what they want to hear and not wanting to deliver bad news. Presumably, during your long career, you've had to deliver some bad news to people up the line. What are some of the strategies that you've used to do that?
First, you obviously need to feel comfortable to be able to do that, which I do. And secondly, you need to work in an organisation where the culture is one of speak up, and that is encouraged. And I very much feel that I am working in an organisation where it is encouraged to do so, where we are encouraged to do so. So how do I deliver it? Look, actually, sometimes I probably just get on a call first rather than fire off an email with the paper trail involved in that, my litigation background there. I think that's because you get the opportunity on a call to try and get some more context and ask some questions on the fly and get some answers on the call, and then move from the call into, if you need to send emails around, marking them privileged if you think there's going to be an advice aspect in that as well. But it really is a bit of a combination.
I just want to pick up on something you said before there about the idea of the culture being able to speak up. And so that sounds like it's a leadership, something the leadership can do. What is it then about your current place of work that you think has given you that sense that it's okay to speak up here? What can people do to create that kind of culture?
Sure. It absolutely starts at the very top. So for us, we have company values. Our company values are published on our website. They're available for everyone to see publicly. And as the company, we encourage all the employees of the company to implement the values and work towards the values. For example, one of our values is push boundaries to discover what's possible. To me, I interpret push boundaries is if I want to say something, say it. Don't be afraid not to. So they apply across the whole company, whether it be the board, the executive, the senior leadership team, sales, business support roles. We're all working towards that bigger picture of what we value as an organisation.
Yeah. So do you think then that, what would be the role of in-house counsel? Say someone does speak up and, put something out there, there's an incident of some kind and they want to report. Does in-house counsel have a role there at that point? And what would be the role of in-house counsel when someone does that?
Okay.
If it's not you speaking up to someone else, or if you spoke, if
sure.
Speaking up.
So in financial services, we work to an incident management policy. And when we're talking about incidents there, it's not just a data breach or privacy or, an IT issue. It could be a whole range of things. And we have a policy and processes regarding incidents. So if you, in your role, identify an incident, you follow the policy, you log it, and it goes onto our incident register. Then my legal role from that point on, once I've identified it, is to advise legally on the incident. For example, is this something that needs to be reported to a regulator? That's essentially my involvement. The management of the incident and the remediation sits within others within the team, the appropriate team.
So that's not a legal thing, that's more of an
operated,
operations thing.
Yeah, exactly.
Yeah, okay. Going back then to this idea of who is the client. I mean, within government, it's a bit different because you've got lots of different departments and, you can tell us, well, the client's the state of New South Wales, the client's the Commonwealth. But when you're in-house, your client's the company. But have you ever felt that something that, some bad news you need to give or something you need to say, might be for the better for the company, but the particular team within the company that you need to give it to isn't going to like it? Have you ever felt that kind of conflict or pull between who your client really is in a situation?
Not in terms of who my client is. Yes, you can understand that people might not like it, but when you have this strict process anyway, it kicks into play. It's here you go, here's the process, here's how we manage it, and we just follow it through and make sure, it's remediated and everything that needs to be done is done. So everyone's sort of very mindful of that now, that I wouldn't ever feel that there was a culture that, I can't act and deliver that bad news.
So in other words, establish clear processes and make sure they're
Absolutely.
stuck to. Okay.
Yeah, absolutely.
You might well know that the Army is a very hierarchical organization. We really like our lines of reporting, we really like our chains of command, and we really don't like people stepping outside of those, which means that it's very significant when the Brereton Report recommends that there should be a safe reporting line outside of the chain of command to report or discuss concerns about unlawful behavior. Do you feel that in-house counsel have an ethical responsibility to encourage employees to report wrongdoing, even if it might mean them going outside of their reporting lines or going around their bosses?
I'll probably give the example of linking into our whistleblower policy. So the operation of our whistleblower policy is pretty standard corporate governance. It's available publicly on our website. You can see what our process is. But under that policy, we also have an anonymous reporting line. So if people don't feel comfortable raising it directly with their manager, you can do so anonymously. We have an independent whistleblower hotline that operates independently of the company, but also the legal team take on the responsibility of training the employees in relation to that policy. And that's from the new starters coming in, doing their orientation. We're the ones that are advising on those obligations on that policy and what's available.
So that's not a HR kind of thing of
that is being delivered, but there's obviously a divide between what HR people and culture, the policies that they're training on, but whistleblower is currently sitting within the legal team.
And is that because there are now just so many legal requirements on public listed companies?
I think we look at it from the fact that it's on our corporate governance page. We look at that as one of good corporate governance practice. And the legal team has both the legal team plus the company secretary team. So it's advising on obligations that would sit underneath legal and company secretary.
I don't know if anyone in the audience has any questions, or do we have any online, Jackie?
No, look, I think this has been an absolutely fantastic discussion. I'm really grateful Kate, that you've been able to join us tonight to talk about these really important issues. Thank you very much. Thank you, of course, to Dr. Amanda Sapienza. I'm Matthew Cobb-Clark.
Thank you to Matt as well.
Yep,
and to Jackie, our wonderful clerk, who's taking care of
who's been sitting off camera, carefully monitoring the online stream to make sure it goes as planned. And thank you, ladies and gentlemen, for tuning in tonight.